Yes. All the list.
Application. And what happened in the trial court? But in the trial court,
All the list.
Petition was earlier filed before the single bench, as because section 14 and 15 of Foxfare was there. Subsequently, section 6 of the Foxfare.
All right. Perused report.
This is second judge's copy.
Perused report. Appellant, petitioner is directed, department is directed to peruse report. Department is directed to renumber the case and place the matter before the bench tomorrow. All right.
Here's the second judge's copy.
You produce the case diary.
Does it victim not notified?
First, you produce the case
filed the
got case
affidavit.
diary.
No, case diary returned to the trial court. Yeah, I'm calling for.
To bring it. Photocopy, bring the photocopy. Don't.
I have the 207 copy. 207 copies.
Very good. Next.
I have filed the second judge's copy.
But there's a correction mark. In the satisfaction part. Instead of ACGM refund one, it should be additional session judge refund one. This is also matter.
Next.
My lord, I beg to appear here with the petitioner. The allegation under section 8, read section 21C, 25, 29 of Narcotics, Drugs and Psychotropic Substances Act. My lord, in this case, my lord, there is no independent witness. My lord, kindly come to page number 12.
All these are no ground for this.
There is no videography evidence also, my lord. My lord, in a self-same cause, my lord, I have annexed the order, my lord. My lord, kindly come to page number 25 of this bench. We
Yes,
have
which was
considered.
state.
NCB. NCB.
My lord, when the seizure occurred, no one was present. My lord, there is no videography evidence. My lord, moreover, my lord, this
Madam, your other side is not there.
My lord.
Yes,
I don't know if I will.
yes.
my lord, my
They
lord,
say that there is no videography of the recovery.
my lord, moreover, this contraband was seized from another person's house, my lord, Zakir Hossain, not from the petitioner's possession.
What is their complicity?
My lord, this petitioner led the raiding team to the spot from where 16,000 bottles of fentanyl was seized.
All right. So where is the leading statement? And where is the videography of the recovery?
My lord, videography is not there.
Then,
My lord,
My lord, I need to explain. I have asked the officer.
yes, give a report.
Yes, my lord. Because it is mandatory part.
Petitioner contends that no contraband was recovered from his possession. He has been falsely implicated. Alleged recovery is not supported either by independent witness or videography. Deputy Solicitor General seeks time to submit response to the aforesaid issues. Report be filed on the adjourned date. Matter will appear before the next available search.
Lord, in 6, I appear for the petition. My lord, this pertains to a criminal case wherein, my lord, your lordships have been pleased to grant a bail to, my lord, a co-accused person. My lord, the issue therein was on the basis of confessional statement of the, my lord, principal accused. No recovery was led to. Lord, I stand on a better footing. So far, I have perused the lower court records. There is no seizure from my possession, as well as, my lord, there are no leading statements.
Petitioner contends no narcotics was recovered from his possession. Who accused? He is in custody for
35 days.
you also 35 days.
Yes.
Previous was 35.
36.
He was arrested on
36.
maybe 36.
26.
As well 26th
Same-
He was subsequently
Same
arrested.
day.
26th of December.
Both of them,
No, no, he was subsequently arrested.
then how can it be 36 days?
No, that was earlier, but they.
All right,
No, no,
he is in
the other
custody
one
for
was-
36 days. Co-accused has been enlarged on bail, he prays for bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. No narcotics was recovered from petitioner. Co-accused has been enlarged on bail. Petitioner is entitled to similar relief.
Deeply obliged.
Madam, for the petition. But this is a NDPS case, but I'm praying for a humanitarian ground, my lord. But this,
What?
the brother of the petitioner had died on 24th of January. My lord, kindly, my lord, give me some interim bail, my lord, I will, my lord, perform the, my lord, last ritual of my brother, because no one,
Whether his brother actually died.
my lord, I have annexed the, my lord, death certificate, kindly see page 11, my lord.
State petitioner seeks interim bail on the ground that his brother has died and there is no one to perform the funeral, the last rites. State shall submit report tomorrow.
Tomorrow.
Yes.
My lord, item 8, my lord, I am for the petitioner. My lord, the offences are, my lord, 64(2)(a)(1) and 351(2), my lord, of the BNS. My lord, these correspond to, my lord, 376(2)(a)(1) and 506 of the Indian Penal Code. My lord, the petitioner, my lord, in paragraph 2, my lord, there is a mistake. My lord, petitioner has been referred as a self-employed person. My lord, he is not. My lord, he is, my lord, a sub-inspector of police, my lord, and he is posted at second officer of Rajganj police station. Now, my lord, if your lordship will kindly have, my lord, this short list of dates. My lord, this is the, my lord, third case, at least the third case within our knowledge. My lord, with regard to, my lord,
Victim has been
376
notified?
lordships.
Not different from but your lordship, we have not served any, we have not been served any copy, we have not received any copy yet of the application.
Give a copy to him.
My lord. My lord, the case is, my lord,
Yes.
Can you permit to give some time so that we can take
Tomorrow?
instruction tomorrow?
tomorrow.
Highly option.
Any problem?
No, my lord, there is no problem.
Tomorrow let him look into it. It alleges that your client has lodged a series
Number of
of
cases.
cases alleging rape by various persons.
Your lordship, I have been instructed to take,
Take instructions,
I'll have to take instructions and I'll have to
come back,
go through the,
yes, come back tomorrow.
come back.
Very good. Tirupati. Tirupati.
You went to Tirupati.
For the petition, my lord. Petition.
Yes, next.
Sir, I am for the petition, my lord. Petition before your lordship with the father-in-law, my lord. Allegation under section 85, 76, 77, 109, 3 and 5.
Yes.
Of the Miller BNSS Act, my lord. My lord, the petitioner before lordship with the father-in-law, my lord. He was in custody 63 days, my lord. But the de facto complaint it left her matrimonial home, my lord. The copy was served upon.
Yes, what do you say?
Yes, the marriage took allegation is against the father-in-law and the section is 64F of BNSS. The allegation is very serious in nature and since after the marriage, marriage took place in the March of 2024. After the marriage, there is a very bad eye toward the victim of her father-in-law. And thereafter, on 24 October, this such incident happened and in 25 they attempt to murder and then 20 lost complaint. The allegation is very much serious in nature, my lord, against the father-in-law on whose full trust upon him. But
How long you are in custody?
63 days in custody, my lord. My lord, the husband of the de facto common lodge, my lord, matrimonial case for restitution of conjugal rights.
When?
My lord, it was filed on, my lord. My lord, it was filed, my lord. I have annexed the copy, my lord.
When?
It is recorded that on September, but it is pre-conspiracy.
Milord,
to escape
17,
from this
7,
crime.
maybe it was filed on.
They have already know that such kind of.
Milord,
content will be
17-9, Milord, I have
documented.
filed the Milord.
In the on 17-9, when, what have you pleaded, where she is residing?
Yes.
No, she was residing at
Matrimonial-
Milord, at matrimonial home, Milord. I have,
We are not, we have asked you what is the pleading in the plaint of restitution on 17.
yes, your lordship. I have annexed
And where, what address have you given and where she is residing?
her matrimonial home, Milord. Kindly see,
Our
Milord.
matrimonial home is
Her
your residence.
father home, Milord, sorry, Milord. Her father home, Milord. I have also
Our
made,
other home.
yes, your lordship.
I have been.
Milord, I have
residing at
also made
matrimonial
in
home at
paragraph
that
7,
time.
Milord. I have also written in paragraph 7 also, Milord.
It
Yes,
is a
when-
conspiracy. my
When
lord.
was it served? The
It-
service?
Milord, service, Milord, kindly come to the page number.
Matrimonial suit service.
Milord, it was third one, Milord.
It is not served. here.
Milord, Milord, it was some, Milord, kindly come to the annexed
Show us
P2.
the service.
Milord, I have some, kindly come to the annexed P2, Milord. After they have appeared, they have.
Show us the service. P2. Let us see. Ah. Whenever you are annexing some document which have identity, redact and annex a photocopy of it. Yes, there's nothing to prove service.
Yes.
What is just a matrimonial suit?
Annexed P2, Milord. This is the matrimonial suit I have filed, Milord. Milord, they have appeared, Milord. They are
No, I know they have appeared because they have come to know otherwise. Service never took
the
place.
service happened, Milord. Then thereafter, Milord, they appeared, Milord. Order copy is also annexed, Milord.
We are seeing the order copy. That is in December they have appeared.
Milord, kindly.
Before that, they have lodged the case.
No, Milord. After I have the service made, Milord, they have, thereafter the FIR has been lodged, Milord.
No.
Milord,
Sir,
Milord, kindly make you.
you can shout very strongly, but the document says otherwise. Otherwise, we wouldn't have told you. Just see the document. The document says that your service is not there. But still then, they entered appearance. And they entered appearance. Mera page mein to nahi hai.
Yes, your lordship.
Kindly come to page 12. It is indicated the SR returned after being not served.
Not, sir.
And
Yes,
respondent appeared on 17/12 December
Then,
and complaint lodged on October 28.
when?
Milord, in the pleading, Milord, I have stated, Milord,
This is
that.
a
What have they
pre-conspiracy
stated?
to
So
escape
you-
from
if
this
I,
crime.
if you
kindly-
say, wife is staying XYZ
Milord,
and wife is staying with you,
Milord, kindly, on accommodation, Milord, tomorrow I will produce the document, Milord, according to my, Milord,
nothing.
Milord, kindly, Milord, one day, Milord, kindly, Milord,
It is
Kindly,
reflected in
Milord.
the order sheet, Lordship.
kindly, 63 in custody.
No, the restitution, 9. FIR is in October. And what I said is, we have filed the FIR and given her out of the house. Who?
Milord, kindly, accommodate one, tomorrow I will produce.
Tomorrow.
Yes, your lordship. Yes, your lordship.
Reevaluation may be in.
I'm for the state. Allegation
I
under
put the defect of complaint.
126 to 115 to 118 to 109 and of the BNS, my lord.
Yes, nature of injury.
My 68 days in custody, my lord, charge sheet submitted, my lord. My lord, both are brother, there is enmity property dispute. quarrel
No, there
between
is
two
no
brothers.
enmity in the property dispute. Petitioner is the full-blooded brother of the informant. My lord, the petitioner blow with the dagger with the head of the petitioner, in the head of the informant. Informant, my lord, resist with his hand. As a result, the informant, my lord, 30 stitches in his head and my lord, 59 stitches in his hand, my lord. Kindly see the nature of injury once, my lord. And thereafter, my lord, in several occasions, the petitioner went to the several officials but did not take any step, my lord. Subsequently, went to the additional SP and my lord, thereafter, as direction of the additional SP, the investigation officer, after 1 month and 3 days, recorded the 164 of the petitioner, 164 of the informant, my lord.
How long is it custody?
And my lord, thereafter, my lord, also my lord, the informant is in my lord 3 years held by the petitioner.
All right.
And his family
Petitioner
members, my lord.
contends that there was a free fight. He had no intention, allegation, he has been falsely implicated. Investigation is complete. He pays for bail. Learned
Oh,
lawyer
kindly
for
see
the
that.
state opposes the prayer. Learned lawyer for de facto complaint and submit. Petitioner had assaulted him on the head. He is continuously threatening him. We have considered the materials on record. Petitioner and the de facto complainant are brothers. They had a quarrel. Petitioner assaulted, it is alleged petitioner assaulted the de facto complainant on the head and hand. He is in custody for for 68 days. Investigation is complete. Full stop. Under such circumstances, we are of the opinion further detention is not necessary and petitioner may be released on bail subject to conditions. Petitioner while on bail shall not enter Holdibari police station until further orders and provide the address where he shall reside. Okay. in the supplementary charge sheet, though in the supplementary charge sheet, petitioner is shown as an accused, no specific charge under section 302 simpliciter has been leveled against him. Full stop. It was also noted that petitioner was available to the investigating agency as he had surrendered in other cases and had been released on bail. No explanation was the aforesaid incongruities. Now, in light of the aforesaid incongruities, a report was called for. The state was directed to clarify the following issues set out. The report is placed on record today. Today, report is placed on record. The report is clearly, the report is awfully vague. In the report, the report is awfully vague. Apart from stating that petitioner was not cited as an accused in the initial charge sheet due to non-availability of records, no cogent material is placed before us for this remissness. The aforesaid lacuna prima facie discloses lack of confidence in the investigating agency with regard to the role of the petitioner, with regard to the principal role of the petitioner in murdering the police, in shooting at the police officer. If that were so, if the investigating agency was satisfied with regard to the credibility of the complainant's statement in the first information report, non-availability of records would not be cited. Petitioner would have been cited as the principal offender and This was not done. Now, for reasons best known to the investigating agency, this was not done. Presently, the agency is and even now, this was not done. No convincing explanation is also offered. Now, apart from taking an evasive plea, that is non-availability of records, no convincing explanation is placed on record. In the supplementary charge sheet also, petitioner is arraigned with other accused and not as the principal offender, arraigned with other accused and charged under section 90 and charged under sections 353, 120, B, 307, 302 IPC. No separate charge under 302 simpliciter has been labeled against him. Has been leveled against him. Full stop. The tenor of the accusation in the supplementary charge sheet also gives an impression that the investigating agency itself, tenor of the in the instant case, the facts transpiring from the charge sheet, facts transpiring from the charge sheet show there was a skirmish between the police personnel and a group of individuals, including the petitioner. one of the police personnel, SI Amitabh Mulli, suffered gunshot injury and died. In this backdrop, now, taking note of the omission of the petition in the initial charge sheet and the generic accusation and the generic manner in which he has been cited as an accused with others in the supplementary charge sheet bracketed without citing him without charging him for the offense of murder simpliciter, gives an impression that the leads to the irresistible impression that the investigating agency prima facie was not satisfied, investigating agency in light of the group violence resulting in death was not prima facie satisfied with the sole and uncorroborated version of the complainant with regard to the principal role of the petitioner in the murder. If the principal role of the petitioner is discounted, what remains are general allegations with regard to his presence at the place of occurrence and running away from the spot after seeing the police attack the camp. Full stop. It may not be out of place to note, to bear in mind. You may not be out of place to bear in mind the fact the petitioner was leading a political agitation against the political executive in the state. Possibility of embellishment, embellishment of the petitioner's role in the crime possibility of embellishing petitioner's role in the crime for political reasons cannot be also ruled out. It may not be out of place. It is also relevant to note that the state has withdrawn some of the criminal cases against the petitioner. No cogent rationale for withdrawing some of the cases while maintaining the others is also has been articulated before us. We are conscious petitioner has been accused of conspiracy to commit murder, which is a very grave offense. Conspiracy to murder a police officer, which is a very grave offense. However, as discussed earlier, principal role of the petitioner in the murder appears to be based on the uncorroborated version of the complainant, which in the first instance was not accepted by the investigating agents. Full stop.
Based on uncorroborated version of the complaint, which in the past was not accepted by the
and the petitioner was not named in the initial charge sheet. Appears not to have been taken note of by the investigating agency. Whether such omission, whether such omission, it is not in the subsequent, in the report filed before us, it is not stated that the omission was inadvertent, but is sought to be glossed over by claiming that the petitioner was not cited as was not cited in the initial charge sheet due to non-availability of records. Due to non-availability of records. This explanation is patently preposterous and difficult for us to digest. Full stop. Custodial investigation of a grant of anticipatory bail, particularly in cases of murder, is an exceptional remedy. However, it is an exceptional remedy. But when the investigation process appears to be directed more for but when the investigation process does not appear to be fair and indicates and discloses elements of bias for ulterior objects, elements of bias with ulterior motive. It is the duty of the court to ensure the liberty of the citizen, ensure that the liberty of the citizen is not whittled away under the guise of criminal investigation and prosecution. State appears to have blown hot and cold in respect of the petition. In the first instance, the prosecuting agent, the investigating agency, notwithstanding glaring allegations against the petitioner, did not cite him in the charge sheet. Though it is contended, petitioner had absconded and warrant of arrest is pending, no explanation is forthcoming why the warrant was not executed, though in spite of the petitioner being available to the investigating, in spite of the petitioner appearing in criminal cases, appearance in criminal cases, and being available to the investigating agents. In such view of the matter, we are of the opinion the investigating agency itself is not serious in pursuing the process against the petitioner. This prompts us to pass appropriate orders granting anticipatory bail. Hello. We don't appreciate this sort of mockery of justice. And we really feel sad for the family of the police officer whose life is not even an iota of importance to the state. Speaking for myself, I cannot even imagine a police officer not citing a man as a charge-sheeted accused when an IC of police says that I saw that man shoot at my colleague. Either you don't believe your IC, that is why you have not charge-sheeted it, that it's an uncorroborated version in a case of group violence. Or alternatively, at that time, for whatever ulterior motive and consideration, you were screening the offender. So why should we now take his liberty after 4 years? Don't play with the process of criminal justice. Next.
Okay.
Lord, I for the petition, my lord, allegation under section 85, 109, 35, 351 of the criminal code, my lord. 15 years of marriage, my lord, petition before lordship is the brother-in-law, my lord. The defect of, the son of the defect
Any
of complaint,
specific allegation?
No lordship, no specific allegation.
son of the defect of complaint.
25,000.
Yesterday, lordship, the husband was granted bail, lordship. No specific allegation.
We have considered the materials on record. Petitioner is the father-in-law of the victim lady. Allegations of torture are general and omnibus. Accordingly, we are inclined to grant answer.
Lordship, brother-in-law,
Brother.
brother.
आपको आपका प्रॉब्लम है क्या? आप Lodging papers, even in the charge sheet. Then again, when the name appears in the punch of the key, giving an impression of construction liability. And no charge under 22 simply.
Team has been is residing within the jurisdiction of Sikkim. Mail has been sent to Gangtok SHO for confirmation. My instructions are that. it
Kindly
has
see
been
the cross
served.
examination. 5 year, 1 month, I'm in custody.
What is this?
The bail in connection with appeal.
Next available, sir.
Should the report.
Next victim, Mr. Ganguly seeks time to serve the, submits that the victim is in Sikkim and prays for adjournment. Matter will appear before the next available, sir.
Lordship, in item number 16, I am praying for short passover, lordship. Subhasis Mishra is appearing, lordship, is in court number 2, lordship.
This is a bail in connection with appeal, lordship. My lord, I have served to the my lord, the de facto lordship, it is affected, service is affected. Now, lordship, the petitioner has, the appellant has been convicted for 20 years for the charges under section 6 of the Protection of Children for the Sexual Offense. Now, lordship, apparently the case is very bad. My lord, as per the FIR, the victim is a shopkeeper, the grocery shopkeeper, where the two victim girls went to buy some snacks, kurkure. My lord, he called the two victim girls inside the shop room to give him a head massage because he was suffering from headache. Two victim girls entered into the shop room. He pulled down the shutter. Thereafter, my lord, the offense has been committed upon both the victim girls. This is the prosecution case as well as the my lord FIR. Now, if your lordship kindly comes to the depositions of the PW7, who is the medical officer, my lord, deposed that, my lord, there is no medical injury either of the girls, my lord, no hymen ruptured, and my lord, the sexual harassment cannot be ascertained without the FSL report. Now, my lord, extent of penetration is not a matter, my lord, but lordship kindly see the depositions of the PW2 and PW3, who are the victim girl number 1 and victim girl number 2. Both of them in their cross-examination deposed that, my lord, during the occurrence, my lord, they cried on pain, my lord, the penetration was to such an extent, my lord, that blood was oozing from their private parts, and to such extent that their wearing apparels were soaked as the wearing apparel of the accused. But those wearing apparels were not seized by the police, not handed over by the de facto mother to the police, and not seized. My lord, the FSL report that has come subsequently after filing of the charge sheet, my lord, that FSL report says negative. Now, lordship, kindly see the depositions of the PW number 1, who is the de facto complainant, as well as the mother of the victim girl number 1, and PW4, who is the mother of the victim number 2. They both said that we waited for the money which assured by the accused. My lord, if the money had given to them, they would not lodge the complaint. Well, there is a background of the case, lordship, that the accused is a shopkeeper. He used to give credit to the villagers. He used to give credit to these two families also, and there was an altercations relating to not paying the credit to the shopkeepers. And on the date of occurrence, there was a altercations relating to 500 rupees. And lordship will get from the depositions of the PW1, who is the de facto complainant. She deposed in her cross-examination that after that occurrence, my lord, that accused came to their house, and there was a talk relating to 500 rupees and a hot altercations between the grandfather of the victim number 1 and the accused. My lord, the grandfather, as per the depositions of the victim number 1, she stated the entire thing to her grandfather first. So grandfather knew everything. Even then, my lord, after the incident, when the accused came to their house, the grandfather did not say anything relating to that alleged occurrence. They are more busy about this 500 rupees, lordship. Now, if your lordship kindly comes to the depositions of the PW5 and 6, they are the neighbors. PW6 stated, my lord, that dispute relating to 500 rupees which was stolen by the victim girl from the shop of the accused, and that is that accused, my lord, told that issue to the villagers, and therefore this FIR has been lodged against the accused. Now, your lordship kindly comes to the depositions of the PW7, which I have stated earlier, my lord, who is the medical officer. She stated nothing about the sexual offense. She stated that the FSL report will come. Thereafter, she could opine whether sexual harassment took place or not. That FSL report ultimately came negative. And my lord, if your lordship kindly go through the PW8, who is the investigating officer, my lord, she stated that she have not recorded the statement of the medical officer, neither she recorded the statement of the scriber. There is no signature of the scriber in the FIR, lordship. And my lord, the scriber has not yet been, my lord, not been cited as a witness, charge sheeted witness, nor his statement has been recorded. And lordship, relating to the place of occurrence, lordship, the prosecution case was both the victim went into the shop room, both were ravished by the accused persons, where the victim girl number 2, who is the PW3, she in her cross examination stated she stood outside the shop room, and the victim girl was inside the shop room. And when she heard the cry about the victim girl 1, she entered into the. Therefore, my lord, shutter was pulling down. That story cannot be believable. Whereas, my lord, victim girl number 1, she stated in her deposition that after the occurrence, my lord, she went to the market. But the prosecution cases, both were ravished, both were driven out by the accused from their shop, both came together to their respective house. So, lordship, there is various contradictions, my lord, relating to the everything, lordship, relating to the, my lord, the medical, relating to the depositions of the both the victim girls, relating to the depositions of the PW1 and PW4, who are the Who are the
5 and 6 were declared hostile.
not declared hostile? My lord, I have page lordship 5 and 6, page 103 and 104. বলেছি। Witness number 5 said there was only one room in the shop. So, my lord, prosecution story was they were taken to the shop, to the inner chamber of the shop where, my lord, the alleged occurrence took place.
The appellant contends that the prosecution case is riddled with inconsistencies. Riddled with inconsistencies. He submits the occurrence was concocted as occurrence was concocted as he was unable to pay the money demanded by PW1, mother of victim 1. There is delay in lodging first information report. Manner and circumstances in which the incident occurred also raises doubt. It is unclear how the victims ran away from the spot. It is unclear when the shutter of the shop was closed, how the victims fled the spot. No injuries were found in their medical officer PW7 did not find injuries in their private parts, supporting penetrative sexual assault. Accordingly, the appellant prays for bail. Learned lawyer for the state opposed the prayer. He contends victims are minors. Appellant had lured them into his shop and committed rape. PW1, mother of one of the victims, approached the police but was resisted by local people. They forced her to sit in a shalish where appellant was directed to pay money. This caused the delay in registering FIR. Evidence of the victim with regard to sexual assault is corroborated by other evidence. We have considered the evidence on record. PW 2 and 3 are the minor victims. They have stated that they were called to the shop they were lured into the shop by offering snacks. Then the appellant told them to massage his head. At that time, he committed rape. Full stop. The victims fled the spot. These circumstances, the version of both the victims are substantially corroborated. Both the victims substantially corroborate each other. Minor variations in their version is they are young girls aged around 11 years. Minor variation in their version is understandable. Absence of injuries per se would not improbabilize a case of penetrative sexual assault on a minor. PW1 has explained the delay in lodging first information report. She was prevented to seek legal recourse due to local intervention. Demand of money, possibility of false implication due to demand of money appears to be improbable. In light of the aforesaid materials on record, and the gravity of offense, we are not inclined to suspend as well. Paper books, PCR has been received. Paper books within 8 weeks.
No, no, APD.
Every service given. Yes, next one.
Your Lordship, I'm for the petitioner. In this case, I've come for modification of the bail order as granted by the Honorable Court. On the other day, the co-accused order had been modified. I have annexed the order of the Honorable Court.
Complied with the condition.
No, Lordship, page number 19 and 20 earlier, wanted bench relax other two accused condition.
We are asking whether this person had complied with the condition or not.
Yes,
If others have been relaxed,
No.
if he does not comply with the condition.
No, they are not for Thana Hazira with the Lordship. They are for attending the Bagdogra PS instead of Darjeeling.
Why should they attend?
So
What
he-
is the direction?
the
That they
direction.
shall not enter the jurisdiction of Darjeeling district.
Yes, Your Lordship.
Have they complied
he
with
has
that
complied with-
condition?
Lordship, no report.
Then
He
get
has
that
complied
report.
with all, he has not entered the jurisdiction of Lordship.
That report should be there.
Yes. Lordship.
Kindly
Report-
keep it for tomorrow, Lordship.
Get the report tomorrow?
Yes.
Report be filed. Adjourn for the day. Yes, Mr. Bowman.
Lord, I am for the OP, item number 8.
Item number 18. Lordship, I am for the appellant. Individual service.
I have appeared.
Yes, appear.
My lord, the can one is a delay for 127 days.
Or
My lord.
delay may be condoned and the
Uh,
other side may be asked to have the copy of the main petition.
Lordship, I'm
What main petition? This appeal will be heard.
No, I did not get any copy, my lord.
Paper books will.
Paper
be
books,
handed
there
over to
there
you.
is paper, lower court records, Lordship, there.
What dismissal of specific relief?
Lordship.
Suit for specific relief.
Short for dismissal, no?
Then?
Decreed,
Oh, decree.
decreed.
Decreed in my favor.
In decreed favor of the Mr. Bhaumin.
Have you put in the principal consideration of 2 lakhs?
Lordship,
Have you put in the the amount of 2 lakhs?
2 lakhs court fee, Lordship. No, no.
What is the decree?
Consideration.
Consideration money, he has to pay, Lordship. He has to pay. I am
The
no.
plaintiff will pay.
Plaintiff. He is plaintiff. He
Yes,
is
so
plaintiff.
have you deposited the consideration?
Get some instruction, my lord. I am not sure about that.
What we say is that you keep the consideration money deposited. And let it remain in a nationalized bank.
Lordship,
All right,
Lordship.
subject to the result of the.
The subject of the.
And there shall be a status quo in respect. of-
Lordship, please. Lordship, so far can is 2 is concerned, that will stay, Lordship, because of the decree as in operation. Stay,
No, because he will put the decree into execution, right?
Lordship.
So can one
Is a 127th day, days delay,
delay
Lordship.
is condoned? What is can 2?
Can 2 is the stay for the execution of the decree, Lordship. আমি দিয়েছি কিন্তু তাও আমি দিব
Can one a copy টা আছে?
আমি দিয়ে দেবো।
Okay, one page.
No limitation.
Thank you. Yeah, okay. The her counsel secretary shall be impugned, judgment and decree shall remain stay till disposal of the appeal. However, respondent shall deposit the consideration money of rupees 2 lakhs. No. In terms of, no, however, respondent is at liberty to deposit the money of 2 lakhs in terms of the impugned judgment and decree before the trial court, and in the event such deposit is made, the same shall be kept in an auto renewing fixed deposit maintained with the nationalized bank, subject to the result of the appeal, right? So that the money is done and the injunction will continue, however. The injunction, there shall be an order of injunction. What is the injunction? Where is the plaintiff?
There is lordship, his number. It doesn't say, it might.
Stay with it.
Very fast.
There shall be an order of status quo. There shall be an order of injunction preventing the appellant from selling or transferring the land. Hey, sorry.
Respondent.
Upon the defendant, that is you.
Yeah, defendant, I am the defendant.
So you are restrained from selling.
I'm not transparent.
All right, there shall be an order of injunction restraining the appellant, defendant, from transferring or from selling and or transferring the land to any third party till the disposal of the appeal. All right. Can is this. Paper book appellant shall file requisite number of paper books within 4 weeks. Trial court records call for notice of appeal is dispensed with. Mr. Bhumik enters a notice. Next circuit. Somebody else.
Lordship, we have for the appellant.
On behalf of the respondent, Lordship, this matter was been led by Kalyan Sarkar, Lordship. Lordship, due to his medical, he has got his eye operation, Lordship. So playing for the next circuit.
Next, sir, on the prayer of this.
Yep, ma'am.
Program Seva. Ram Ram.
21, Lordships. 21 and 22. 21 and 22 are for the appellant, my lord. One of the appellant already expired. And they have been convicted for 7 years punishment. They have, Shamol is convicted 7 years, he is alive. No, that is not my contention. There are 2 appeals were hard together. One of the appellant already expired.
Who has it?
My lord,
Who has expired?
Student Rai.
Suren Rai, do the heirs of Suren Rai propose to pursue the appeal?
No, my lord, there are two appellants.
When an appellant expires, what is the result, Mr.
Then-
Joydeep Bhowmik?
That will be, if the legal has,
So the legal heirs should be notified whether they wish to proceed. with
no,
the-
no, my lord, no instruction.
So that is, please give that report, let the state give a report. Who has expired?
Surendra.
Suren. Appellant, oh yes, CRA 38. Suren Rai has expired. State shall notify the legal heirs with regard to their right to prosecute the appeal and their intention to do so. Report shall be filed on the adjourned date. Next available service.
One indulgence in respect of Shamol, one bail petition is pending since a couple of months. And they have suffered already more than half of the punishment.
What is the conviction?
326, 326. And 326 is established by the evidence of the document. That is
Yeah,
another,
how long they have been sent there?
more than 5 years, my lord.
More than 5. Okay. Hey, throughout the system.
5 years, 4th month, 6 days.
What is the sentence given to you?
My lord, 7 years.
7 years.
7 years.
All right. Sentence already under.
Already I'm in custody since last 5 years.
Are you appearing for Suren?
My lord.
So
In both the matter, I have been appointed for the legal action.
can you take instruction whether Suren's legal heirs will pursue the appeal or not?
I have no instruction, my lord, because actually I have been nominated by legal service authority. I have no contact with their legal heirs. If state will take some effect, that will helpful for us.
Then state will take time, na? We can dispose of your Samuel here and now. That is why by tomorrow can you give us the report?
Lots more. I will try my level best to bring the report as because make legal on.
What is the? So, appeals are directed against judgment and order dated 25/9/2009, convicting the appellant of I want it to do nothing. 500 convicting appellant Shamul Rai for commission of offence punishable under section
326.
326 of this. The problem is, Suren has a sentence of fine of 10,000 rupees. If that is not put into execution, heirs will. What is against Suren?
They stand. Lordship, main allegation against the Shamol, your lordship.
Sir, please understand our problem. Your difficulty is you just don't understand what the court wants to communicate to you. We know main allegation is against Shamul. We are conscious that we can dispose of Shamul's appeal. So help us to dispose of Shamul's appeal. Suren has died. If the heirs are not given an opportunity to substitute themselves, the problem is the heirs may be saddled with a 10,000 rupee fine.
Suren was convicted for 3 years. 3 years with the
Their heirs will not go to jail, Mr. Joydeep Bhowmik.
No.
So we are not bothered whether Suren is convicted for 3 years or 30 years. We are concerned about the fine of 10,000 rupees,
10,000.
which can be recovered as land revenue from the assets of Suren. So their legal heirs, Suren's legal heir, required to be intimated whether they would like to substitute themselves. Okay, then next available circuit.
All right, order by first.
Lordship,
I have passed an order. Next available circuit report will be filed. People understand. Without that, Yes, next.
23.
Lord, I am for the state.
Next, sir.
Great.
24.
Mr. Chaudhary. Guys, by 12:30, we can sit for the other. That reference.
Lordship.
Huh?
Lordship, item number 24, I am praying for next circuit, Lordship.
Next, sir.
Much.
25.
Well, I am for the applicant. Well,
What is the
imprisonment for 15 years, POXO 6, custody 6 years.
next, sir?
26.
Next, sir, please.
27.
Same,
28.
same,
29.
same,
30.
same.
31.
30 years.
My lord, actually, after 15 years of conviction period, already he has undergone. Now he is on bail. Now, on 15th of September 2023, he has been enlarged on bail. Now, after that, the person is not in touch with me. So,
All those things we don't bother.
so I would like to take it to the next circuit for taking necessary instruction, my lord.
All right. What was the conviction?
Conviction 3, head of and punishment head of 302 life was there. And 326 and 307, 10 years imprisonment,
All
already
right,
undergone
all right.
15
Next
years.
circuit, Next, sir.
Grateful, my lord.
Wonderful.
31.
Next,
32.
next. Yes.
33.
32, yes.
32.
I'm for the
You want to do?
Next.
What is the conviction?
Conviction is section 4 of the POXO Act, Lordship.
How long, what is the sentence? 10 years.
20 years.
Excellent. That's it. Next,
33.
same,
34.
same,
35.
same,
36.
same,
37.
same,
38.
same.
39.
Lordship praying for next circuit.
Next,
40 and 41.
Lordship, I'm praying for next circuit.
same.
40 Lordship, I have something. The conducting advocate, Mr. Somayati Datta, was appointed by legal ad service. And he is ill and he instructed me to, he is not in a position to conduct the hearings to hand over the paper book.
Lordship, in this matter, Honorable Justice Shobhashati Bhattacharya Division Bench appointed me as a counsel, Lordship, from the legal aid. Lordship,
Already changed.
yes, Lordship.
Oh, yes. Thank you.
Thank you.
Lots.
Next,
42.
same,
43.
same,
44 and 45.
same,
46 and 47.
same,
48.
same,
49 and 50.
same,
51.
same,
52.
same,
53.
same,
54.
same,
55.
same.
Lordship 55, this is the government appeal. Appeal filed against inadequate sentence.
The
Because-
respondent is not there. Next, sir. Next circuit. 57. Same. 58. Same. Yes. 59 and 58.
My lord, 44 and 45.
Yeah. Right.
Gopal, right. That matter, my lord, I was for the appellant.
But
After getting the bail,
it doesn't matter to us. You argue the case, you argue, otherwise we
My lord.
appoint an amicus and do it.
no, my lord, since
Mr. Counsel, we
But-
appoint you as amicus to assist us. Correct?
my lord,
End of story. And if you don't want to assist us, we will get someone else to assist us.
my lord,
Okay?
should I, my lord?
No, today we are keeping it next available, sir.
My lord. My lord, 46 and 47 also. Next, circuit.
All have been
My lord,
fixed for next available circuit. But after bail, someone is not contacting you,
no, my lord, they are absconding.
we are making it very clear. We will immediately dispose of the appeal. As an officer of the court, we will request you to assist us.
My lord, definitely,
If you choose not, there are ample
I'm ready
talent
to
at the
assist.
bar, we will requisition those talent. But we are not bothered about a person who is enlarged on bail to take his own sweet time to come and assist, instruct his lawyer. No.
My lord.
Yes. 59 and 60. Next circuit. 61.
61 I'm for the respondent.
Next
This is a
circuit.
very small matter, my lord. It could have been disposed of, my lord.
Could have been, but if he assists us, then only.
Only small issue. Section 33 is involved with Arbitration Act, my lord. That they have not taken the plea at the time of adjudication of the section 34 application, my lord. Or although that application is not maintainable.
Then Mr. Singhania.
Responding to your lordship.
Nobody for the appellant, Ms. Acharya for respondent, adjourn next available circuit.
Your lordship, there is a direction to file paper book, your lordship. It's lying in the record, your lordship, but the appellant has not yet filed, your lordship. The time has already expired. The order was of second of
Let the appellant be notified.
lordship.
Same.
65 for the state, my lord.
For the respondent number 12, your lordship.
Nobody for the appellant, Swansea for state, Swansea for respondent number 12. Next available circuit.
My lord, I appear for the petitioner. In 66, I am the appellant, and in 67, I am the respondent, my lord. My lord, my appeal, that is item number 66.
Yes.
I have come up against the order to the limited extent that even though the learned single judge was pleased to grant or direct the state government to refund the money which we had paid, yet, my lord, despite a lapse of nearly 11 years, we were given the order, we were given the direction to accept the money without any grant of any interest. That is a limited scope.
Mr. Momenur Rahman was appearing, my lord. The learned additional advocate general had also appeared once.
Notice.
Notice was given.
Sorry, 65, I'm for appellant.
All right. Mr. A, the lawyer is absent with regard to the appellant, West Bengal State Electric Distribution. We are keeping
No,
it.
but West Bengal state electricity distribution is not the main respondent. The main respondent is the item, is the respondent. West Bengal small scale industry, because they are the persons who is supposed to pay the money, not the West Bengal Electricity Development Corporation.
Correct.
Because they have already received the money, they have certified to that extent. Now, as a incentive of 2007 granted by the state of West Bengal, we are entitled to 40% amount which were paid as energy charges on account of
We have heard
subsidy.
you. Where is the appellant? West Bengal State Electricity Distribution.
But appellant is not the West Bengal energy distribution. Appellant, your lordship sees in item number 67, the appellant raised for out.
Distribution company from all.
My lord.
Microfinance or
But I do not know, but they do not have any grievances because there is no fear against them. Because West Bengal Electricity Development.
Issue notice to the appellant, next available, sir. Yes, Mr.
65, no, I am the applicant, my lord, but for your.
Nobody for the respondent,
Yes,
next
I have.
available, sir.
My next matter when they be in the list, my lord.
Next available, sir, please. Always in the.
I'm sorry, my lord, I just saw it.
Where is Mr. Chaudhary? So we'll sit at that death reference, we'll sit at. Please inform Mr. Chaudhary, Dr. Chaudhary and the public prosecutor for the death reference, we'll sit at 12:30. Yeah.
প্রেশার তৈরি হবে না আবার ঝুলি দেওয়ার পরে
advocate. Lordship, the case of the prosecution in a nutshell, if Lordship sees page 2, the FIR lodged by one Saraswati Devnath, the elder sister of the deceased, stating that while his brother was sitting in the motorcycle on 6/6/2023 at 9:30 AM in the morning, the accused at Ashighar Mode, the accused came from behind with a ramdao in his hand and gave blow on the neck backside, and resulting which his brother fell in the ground. The accused ran away, and his brother was taken to the hospital where the doctors declared death. Over the said complaint, after investigation was over, the police submitted charge sheet against the accused person, who was apprehended, Lordship, on the very day after some time. I'm coming to that part afterwards, Lordship. And the prosecution examined as many as 18 witnesses, Lordship. Lordship, 18 witnesses, and after the evidences were over, the learned trial judge convicted the accused, giving death sentence. Lordship, the judgment starts from page 93 onwards.
What is the reason for death sentence?
Lordship, I am coming to that. Lordship, if kindly Lordship sees page Lordship, page one. Death sentence.
Who are the eyewitnesses?
Eyewitnesses, Lordship. There are
One is the eyewitness.
Yes, Lordship. Lordship kindly says the reason given on page 132. Lordship, may I read, Lordship, that portion, page 132, the last paragraph. In the case in hand, the aggravating circumstances are that the murder was committed by the convict after previous planning and with extreme brutality. This murder involved exceptional depravity. The convict murdered a helpless innocent man who was sitting on his motorcycle in front of a tea stall for taking tea, and taking the advantage of the situation, the convict, in order to fulfill his grudge and to execute his ill motive, suddenly came from behind holding a ramdao in his hand and started giving blows. Lordship, I humbly submit before your Lordship, subject to correction, that after scanning of the evidences, I did not find as any single evidence regarding the planning, preparation, and execution with extreme brutality. The prosecution has miserably failed to establish any evidence in support of the finding of.
Did the prosecution pray for a death sentence?
Lordship, the prosecution has prayed for a death sentence, Lordship.
Where?
From the judgment, Lordship, arguments.
One 128.
128.
128, third paragraph.
And falls under the category of errors and paid for death sentence. though in his judgment, Lordship, the Honorable Learned Trial Court has given a reference of Bachchan Singh and Machi Singh and the points which has to be there for giving bringing the case under the purview of rarest of rare. But how these points are applicable in the present case has not been discussed by the court.
Correct. Who are the witnesses? What-
Lordship, now if Lordship allows me to go through the witnesses, Lordship.
So, how many eyewitnesses?
Lordship, eyewitnesses. Lordship, eyewitnesses, 1, 2, 3, 4, 5, 6, 7 eyewitnesses as per me. But Lordship, if Lordship allows me, I can explain that whether these witnesses were at all eyewitnesses and their presence in the PO is very much doubtful, Lordship, from the deposition of other witnesses. If Lordship kindly goes through first PW1, Saraswati Bormon. That is page 55. May I, Lordship? Lordship, page 55, Saraswati Bormon. In her, this is the elder sister and de facto complainant. She claims in her examination chief, and at the relevant time, I reached Ashighar More to purchase flowers for offering puja. I found my elder brother Shapon Bormon was taking tea in a tea stall at Ashighar More with his friend. I saw that the accused Niranjan appeared at the tea stall and assaulted my brother with a ramdao from the backside of his head. So she claims to be present at the PO and witnessed the incident. Now, Lordship, on this point only, Lordship, if kindly Lordship goes to page 70, that is PW9. PW9. Cross-examination, first part, first line. I know Saraswati Devnath, elder sister of Shapon. Father and elder sister of Shapon came to the spot within half an hour from the time of the incident. Now, once again, Lordship, if I'm giving much pain to Lordship to come back to page 55 once again, regarding taking of the victim to the hospital by the PW1. She says, immediately after the incident, police from Ashighar outpost rushed to the spot and brought my brother to Siliguri hospital, where my brother was declared as brought dead by the attending doctor. Now, Lordship, at the relevant time, she says that she informed Now, Lordship, kindly see is the page 55, last paragraph, where a previous enmity story was tried to build up from the PW1, saying that I was interrogated by police. The accused worked with my brother for some days about 4-5 years ago. Thereafter, my brother removed from his job. Thereafter, I heard that accused was planning to murder my elder brother. The accused has a habit of roaming in the locality with knife and other sharp-cutting weapons. Prior to incident, there was a dispute between two families. For that, we lodged FIR against the family members of the accused. Now, in cross-examination, she admits that she did not lodge any complaint regarding the accused giving threat to her parents and roaming around with the knife, sharp-cutting weapon. And Lordship, in cross-examination, she says, immediately after the incident, I informed my parents over phone. But her father, that is PW7, if Lordship kindly sees page 67, says that one Tarun informed me about the incident. So PW1 being present in the PO, witnessing the occurrence and informing the matter to her father has been nullified by her father even and by from other witnesses also. Now, Lordship, another Saraswati, PW1, knew Tarun from prior to the incident, and she says that she came to the court to depose along with Tarun. Now, this Tarun, who claims to be an eyewitness also, does not say in his deposition that he has seen Saraswati at the PO, and neither Saraswati says that Tarun, the presence of Tarun at the PO. Now, Tarun says that with the help of police, myself, father of Shapon and Amit Devnath brought the victim to district hospital. And Saraswati said that she, along with her husband, took the victim to the hospital. Husband is Amit. So the presence of Saraswati is not there, Lordship. Neither Tarun says that he has seen Saraswati, neither Saraswati says that he has seen Tarun at the place of occurrence. Lordship, now, second is that the presence of when the police reach, who took the victim to hospital and presence of police at the PO. Lordship, PW 14, ASI Amit Malik, in page 78, Lordship. He says, I immediately sent the injured to the Siliguri district hospital by a toto with the help of local people. Nowhere the police says that any family member of the victim was present and they accompanied the police to the hospital. PW 17, civic volunteer Niranjan Rai, we called a toto rickshaw and brought the injured to Siliguri district hospital. Nowhere says that presence of any family member at the PO. PW 18, Shapon Kumar Ghosh, the IO, page 85, Lordship. With the help of local people and other police personnel, I shifted the victim to Siliguri Sodor Hospital. So the investigating officer also did not say anything regarding the presence of any of the family members or person claiming to be present at the spot to be accompanying them at the hospital. Now, Lordship, PW 2. Torun. Now, Lordship, this is a vital witness of the prosecution, Torun Roy, PW 2, claiming to be the eyewitness. But his statement under section 164 was not recorded by the police. And he says that he was interrogated by the police, Lordship, in page 58, cross-examination, last line from the last paragraph, just above the last paragraph. I was interrogated by police at the PS after 2 days of the incident. The IO says that he has interrogated Torun at the PO on the very day. This witness claimed to be the vital witness, page 58. 58. But no statement was recorded under section 164 of this witness, Lordship. Now, a vital point I would like to raise before Lordship is the statements of the witnesses, so-called eyewitnesses, under section 164, and how after 7 months they have exaggerated and improved in their version before the trial court, Lordship. Kindly see page 10, page 15, 17 first. page 15 and 17. This is an eyewitness, Lordship, named Bachu Shaha. He says, in answering to question number 9, not even a month has been completed. I and my nephew Shubhorai, that is PW4, went to the market on a bike in the morning around 8 to 8:30 a.m. We stopped at the nearby Indian oil petrol pump to fill up petrol. There was a puri deep fried bread shop beside it, waiting for the puri to be taken. I saw Sopon lying face down on the other side of the road. He was bleeding profusely, had wound on his neck. People gathered there. No weapons were lying by the side. I do not know when and how he was killed or who did it. But this witness, after this statement was recorded, Lordship, on 14/7/2024, 2023, Lordship, I beg to be excused. But this witness, when came before the court to depose, page 65, Lordship, PW6. He says he was murdered by Niranjan Mondal. He was at petrol pump and Puri Sabji shop. At that time, Sopon was being sitting in the motorcycle beside the road opposite of the shop of Pachu. Suddenly, we noticed that Niranjan Mondal came there and gave a blow with a dao on his neck of Sopon Burman. As a result, Sopon Burman fell down on the road on his motorcycle, and Niranjan Mondal was running towards Anchal office. Local people. May I continue, Lordship? Yes. Local people started chasing Niranjan Mondal, who jumped over the wall of Anchal office after throwing the dao on the road. Thereafter, police managed to apprehend him. Police asked me to stand at the spot where the dao was lying. And as per direction, I stood on that spot. Local people brought Sopon to Siliguri Sodor Hospital. Now, Lordship, this was recorded on 22nd February 2024. Within 7 months, the witness improved, and this is nothing but, I humbly submit, Lordship, subject to be corrected once again, this is afterthought. Because Lordship knows better than us that 164 is not a substantive piece of evidence, but this important fact that I have seen the incident, what I ask a question to myself, what prevented this person from not disclosing the same before the learned magistrate while deposing under 164? Within 7 months, he has changed and given the entire version. Now, Lordship, now the incident happened in front of a tea stall. Now, Lordship, kindly sees the 164 statement 10/11 of that Polash. Answering to question number 9, on 6/6/2023, Tuesday, I was making tea at my tea stall. Then the man who was killed came on a bike and stopped in front of my shop, my stall. At that time, another man came from behind him, gave blow with a da, sharp cutting weapon, and ran away. The man fell down, and the people nearby took him to hospital. There he died. So the person in front of whose shop the alleged incident took place did not name me. Maybe he did not knew me even, but no prior for TI parade was made by the prosecution, and no TI parade was held, Lordship. And another is that the PW1 claims that she stood in front of the flower shop where she has seen the incident, which is nearby to the tea stall. The owner of the flower shop, Kalpana. The Kalpana was not brought before the magistrate to depose, and page 69 is her deposition, where she does not say anything regarding me. And then once again, Lordship, no prayer for TI parade was made, and I was not placed before any TI parade for identification whether I am the assailant or not. Now, Lordship, the arrest. Oh, another thing is that Bachu, that PW Bachu, Lordship, in 1517, I have just read that he says that I do not, when he along with his nephew, Shubho, was came to the nearby Indian oil petrol pump to fill up petrol. There, the puri shop was there. They were waiting for the puri, and he saw Shopon lying face down, bleeding profusely. So he did not see the assault in 164, Lordship. But his nephew, the Shubho, he was with his uncle at the bike. When they reached the spot, as per the 164, the murder was already, the incident already over, the body was lying. But the nephew, who was in the same motorbike of his uncle, says details. When the accused came, accused assaulted, and so on and so forth. So the statement, how can the two statement given by two persons sitting in this single motorcycle coming to the place of occurrence at the same time see two different incident? This raises a serious doubt in the case of the prosecution, Lordship. Next, Lordship. Arrest, Lordship. Arrest. Lordship, eventually no arrest memo was exhibited. Now, regarding arrest, Lordship, evidence of PW12, Shubho Rai, he says he chased the accused with a motorcycle, but the accused fled away by jumping a boundary wall. He said the accused was running with a da on his hand. Later, he saw that accused was brought by Boro Babu of Ashikar outpost. Now, kindly sees the deposition of the IO, investigating officer, was a page 85, Lordship. Lordship, second line. On 6/6, first line on 6/6/2023, I was posted at Ashikar outpost as under Bhaktinagar PS as SI of police. During that period, SI Bishwajit Ghosh was the officer in charge of Ashikar outpost. So, as per the so-called eyewitness, the accused was apprehended by the officer in charge of Ashikar outpost, Bishwajit Ghosh. But the IO says that it is he who apprehended the accused. The other police officer says the local people chased and they apprehended the accused. Now, Lordship, the incident happened and the police reached the spot. There is a time gap of 15 to 20 minutes. Now, from the place of occurrence to the alleged place of arrest is only 500 meters. The accused allegedly ran from the PO towards the Anchal office with the Ramdau, and within 15 to 20 minutes, he was sitting there, standing there, whatever, and police went and apprehended him. This raises a serious doubt in the arrest of, and that is the reason, Lordship, the arrest memo was not exhibited. I humbly submit. Now, Lordship, Caesar list. Kindly see the Caesar list. There are discrepancies in the Caesar list even. Lordship, Caesar list is in page 20. There are two, Lordship, place of Caesar at Ashigor Anchal area from the possession, I don't know, from whom seized, accused Niranjan Mondol. Now, 20 inch long with handle's length is 5 inch. Lordship, there are two witnesses. One is Madan Bormon, who has not been examined. Another Bachu Shah. Now, this Bachu Shah says he has signed this Caesar list at the PO, at the PS, Lordship, at the police station. Bachu Shah, page 65, Lordship. Lordship, cross-examination, page 66, middle portion. I put my signature on the Caesar list at the PS. And 2 lines before, police asked me to stand at the spot where the dhow was lying. As per direction, I stood on that spot. So when the dhow was lying in the spot, whichever spot it is, Lordship, the Caesar list says, from the possession of accused Niranjan Mondal. So there is a serious doubt regarding the Caesar also. Now CCTV, Lordship. Ashikar Moor is a crowded place. From the evidences, Lordship will certainly has seen it. And there are CCTV cameras also. But if Lordship sees the evidence of the investigating officer, he did not take the pen to make exhibit of the CCTV. Only the 65B certificate and the Caesar list of the pen drive was exhibited. And rightly the honorable, the learned trial judge negated that portion. The CCTV is not applicable in this case.
Evidence was not there. Electronic evidence was.
No, not there. Lordship, now the Lordship, now eyewitnesses. The arrest.
Yes.
The arrest. Lordship has seen that the arrest, some people, police says that we chased and apprehended. The IO says the accused was hiding there at the Anchal office. The arrest memo was not exhibited. The one witness says he was apprehended by another police officer, the Boro Babu. The IO says, no, it is me who has apprehended what caught the accused. The police witness who reached the spot at first, after hearing the news, says that he chased the accused, but till Ashigor outpost, informed the police and came back to his spot. Now, till this 15-20 minutes, where the accused was there, how can the accused be arrested from the area is doubtful, Lordship. Lordship, the Caesar list, Lordship sees the evidence of Shubho Rai, that is PW4. He says that I have signed the Caesar list, but Caesar list does not bear the signature of this Shubho Rai. So there may be another Caesar list with another weapon which was not recovered and sent for FSL. But when the article, the Caesar, the weapon, offending weapon was sent to FSL, kindly see, Lordship, the FSL, one page. FSL, the page. Kindly see the FSL, Lordship, report. What the FSL has found. Lordship, page 23. 23 is the part, sample, and page 25 is the relevant part. A is a description of exhibit. A Ramda blade swab in mesh cloth. Stain something blood. Now origin could not be determined. Group could not be determined. Disintegrated. Whether it was a human blood or some other animal could not be determined. Now, Lordship, the most peculiar thing is that, if I may place this fact also before for in consideration, the PM report says, PM report kindly says, the PM report says, page 5, scalp hair 1.5 long, black in color. The inquest says, inquest page 3, black hair, the body, dead body. But page 23, the hair was sent for FSL containing blood. They say, Lordship, description of article, it contained a tuft of black and grey cut hair. Now, after the death, while the sample was sent to the FSL, the black hair was mixed with grey hair. So, whose hair was actually sent raises a serious doubt. Salt and pepper hair. whether the invoice says and the PM says the deceased has only black hair. The accused allegedly assaulted the victim with sharpened ramda and profuse bleeding was there. But not a drop of blood was found in the wearing apparels of the accused, as can be seen from the statement of the investigating officer. So, Lordship, having all such discrepancies, the trial judge convicted the accused with death sentence without having any reason behind the same. Lordship, and another point is there, kindly see his Lordship, the order sheet, page 34. Page 34. Now, this was the case was fought by the legal aid author, advocate appointed by the legal aid, Lordship. Page 34, order dated 18/10/2023. Learned Defense Counsel files a petition for medical examination of the accused as he is not medically stable. 17/3/2023 for production and hearing of the petition. Now, the last order 17/11/2023. Sole accused is produced. Learned PP files a petition for adjournment. Heard considered. Prayer is allowed. 20/11/20 for production and charge. So, the hearing of the petition goes away. Now, on 20/11/2023, next page, Lordship, and it turns up to page 35. It appears from the record the petition dated 18/10/2023 filed on behalf of the accused has not yet been disposed of. It was reminded to the court that petition ought to have been disposed of. For 14/12/2023, production and hearing of the petition dated 18/10/2023. Now, 14/12/2023, next page, Lordship, and it turns up. Today is fixed for consideration of charge. Once again, the trial judge forgets about the petition. And the charge was framed, keeping the petition pending till date. Lordship, I told that it was fought by the.
No, it was for.
Lordship.
As a lawyer.
Lordship.
Are you putting yourself at
No,
a
Lordship,
lower
no,
level
no,
than a
Lordship.
lawyer appointed?
But
by-
the mistake happened.
No, is there any mistake, or that was a fraud, a flimsy plea to seek time?
That is the reason.
Let us be clear. Is it a mistake?
No, Lordship.
Or your lawyer was just making a flimsy plea?
Lordship, it was that the court raised this question that you are taking dilatory tactics, so the petition will fail in charge. And
where is that stated?
That order is not there. That is the problem.
Where you
Well, I have personally talked to the lower court lawyer, and this was the version, Lordship. And hurriedly the trial was committed, and Lordship, this thing happened. So
are you making out a case that the person is mentally ill?
Lordship, without the paper book, I don't have any documents in support of the same. Oh,
We are not playing. Are we playing Chinese checkers?
No, Lordship.
We are looking at a life of an individual like you and me. Maybe he has some liability.
Lordship, we gathered information that he has medical documents also in his house.
What medical documents?
I don't know. Prior to the incident, he was attending doctor as per the information gathered, Lordship.
Correct. That only shows that he had some mental ailments.
Lordship.
At that time, whether he was
that ought to have been. No, so this is what.
So you place on record whatever you have.
Lordship. Lordship, we'll try to place on the records.
In the record, is there any document?
No, Lordship, no. Only this much what I have got. No, nothing else. Only this much.
What this one?
Only the petition was filed.
Only petition.
Only the petition.
It did not. No document was.
No.
Where is the convict now?
He's in
Jail.
jail, Lordship.
With jail.
Central Correction.
Central Correction Jalpaiguri.
Let a report be called for on a psychological assessment by a psychiatrist with regard to the mental health of the applicant. Okay. Although it will have little bearing, and you are at liberty to file documents to show that he was suffering from some mental illness. Heard Mr. Ganguly, for the appellant. The contents, the appellant was suffering from mental illness at the time of occurrence. An application had been taken out, which however was not pressed. He seeks leave to place on record medical documents in support of his plea. Appellant has been sentenced to appellant has been awarded death sentence. We are informed that he is in Jalpaiguri District Correctional. Central Correction. We direct the state, we direct the Director General of Health Services to constitute a board comprising of experienced psychiatrists to assess the mental health of the appellant and submit report on the agenda. Secretary, Superintendent of the Correctional Home concerned shall also submit report with regard to the conduct of the appellant in the correctional home. All right? Matter.
Liberty may be granted to place those
We
documents.
have already copy of the order we communicated to the Director of Health Services. Director of Health Services. And the Superintendent of Correctional Home for necessary steps. Matter shall come up. When, give us the date when you don't have,
Within next circuit.
next circuit.
Starting from 10.
না আমাদের তো ডকুমেন্ট গুলো দিতে হবে না থেকে বাড়ি থেকে আনতে হবে না লিগ্যালের তো যোগাযোগ
We are making it partner. Or how can it be next circuit district?
No.
Give us a date.
Yes, Lordship,
that
because-
it is not sitting.
Lordship, I have to
We are not bothered about your, give us a date when the Secovus circuit was.
মার্চে নিয়ে যাই, ঠিক আছে তো?
Lordship 10 days.
মার্চে লিস্ট। মার্চে লিস্ট।
না 10 days ডকুমেন্ট গুলো তো দেবো।
এক মাস পরে বলো, মার্চ মাসে প্রবেশ করতে হবে।
আমাদের সার্কিট নেই তো তখন এখানে। আমাদের সার্কিট 3rd March।
Next circuit is in 3rd March.
No, February, 10th February, Lordship.
So
3rd March থেকে কত মাস পর্যন্ত চলবে তাহলে?
So we are keeping it on 18th of March.
18th March. My lord.
18 March।
18th.
18 March।
আরে প্রিন্সিপাল
আরে ওই জন্যই তো সুবিধা।
My lord. My lord.
You can appear online or
Yes,
physically.
madam. Yes, madam. Yes,
Principal.
My lord. Deeply obliged.
Matter is heard in part. Heard in part. So we records be transcribed. Records be transmitted to the principal.
Deeply obliged, Lordship.
So we'll take the records to the principal bench. And 18th, by that time, get the reports. Finish this.
Deeply obliged.
relating to 65B. Yes, my lord. Khotkar, Sonu, everything was referred, my lord, by the Honorable Supreme Court. And with respect to recovery also, my lord, certain observations has been given by the Honorable Supreme Court in that.
Okay. What are the paragraphs?
My lord.
Have you cited the paragraph?
Let us. Yes, my lord. Paragraph 117 and 120, my lord, with respect to recovery of the articles 117 and 120. And my lord, with respect to 65B, para 49 and 51. Lord, inadvertently, the index page has not been annexed. Lord, after your lordship rises, my lord, I will annex the index page.
Oh,
also.
then you
Yes.
annex it. And this is yours. That's okay. এটা দিয়ে দাও, এটা নিয়ে পাঠিয়ে দিতে। আমাদের সঙ্গে তো যাবে না, পাঠিয়ে দিয়ে তুমি আমায় চেম্বারে দিবে। Thank you.
Grateful, Mr.
এটা নামটা দিচ্ছেন, নামটা লাগবে ইন্ডেক্স